Two more possible strategies to defend a criminal tax charge are to claim negligence or inadvertence. The element of willfulness can be negated if counsel can effectively argue that instead of intentionally violating a known legal duty, the target of the investigation was acting negligently, carelessly, or inadvertently. Of course, the government will retort by trying to prove that the defendant's actions were very intentional and not careless or non-negligent. For example, if you try to argue that your client was just careless or negligent in not filing returns, the government is going to show a pattern of not filing returns and say, after 20 years of not filing returns, this doesn't look like careless or negligence to us. This looks like willful intent. This looks like speeds evasion. Another way to undermine willfulness is to argue that the law was uncertain in the area that the taxpayer or the target was acting in, and therefore there wasn't a violation of known legal duty because the legal duty wasn't certain or clear. What's even more important here is the taxpayer or target's actual knowledge concerning legal duty is irrelevant. Even if they knew they were violating a known legal duty, if the actual legal duty were uncertain or it was an unsettled area of law, this argument may prevail. The bottom line here is that if a law that a target is accused of violating is uncertain, no crime has been committed. Another way to undermine violation of a known legal duty is to argue that a taxpayer didn't know a duty existed in the first place. In other words, didn't know about the law that they're accused of violating. Mistake. The Supreme Court of the United States has held that where a target is accused of violating a law, that in good faith they can show that they're ignorant of or that they misunderstand, no crime has been committed, even where their actions aren't objectively reasonable. One rationale for this good faith defense is the criminal tax provisions were not drafted with the intention of penalizing a taxpayer for innocent mistakes caused by the inherent complexities of the tax code. The Supreme Court has a line of cases that hold that a target of an investigation is not criminally liable where they mistakenly believe they didn't have a filing requirement because they didn't have enough income to require them to file, or if the taxpayer mistakenly believed that they weren't required to file a return if they were simply unable to pay. These defense arguments don't go just to mistakes with the law. They can also pertain to mistakes as to facts controlled by law. A defendant who, though a mistake of fact, unwittingly violates a statute does not act willfully, and therefore no tax crime lies. Another way to possibly undermine the willfulness element is to argue that the target in the investigation reasonably relied on the advice of a professional. If it can be shown that the target showed the accountant or showed the lawyer all relevant source documents, gave them all the information necessary to make a correct call as to what their actions should be, and nevertheless they were told to do something illegal believing it was legal, no tax crime has been committed. However, the reliance must be found to have been reasonable, and the reliance was made in good faith. To reiterate, this defense will not be successful if the government can show that full disclosure wasn't given to the accountant or the attorney at the time the advice was sought. Reliance on an attorney's advice has occasionally been found to be valid, even where the target's objective reliance doesn't seem reasonable. Another way to defeat the willfulness element is to argue mental disease or mental defect. The government is under a duty to show a specific intent to violate the law. If it can be shown through the use of medical experts that because of some medical impairment, the taxpayer was acting under a delusion of the law, a defense may lie. In other words, the target did not have the mental ability to develop the specific intent to violate the tax law.